Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I'm your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota, and I apologize for my tardiness. It's been an end to the week. It has been an end to the week. Oh my gosh. I have missed you all dearly. I have. That is said without a hint of irony. Am I growing mutton chops? No, you know, I need a haircut and I need to shave. I could bore you with details about the past couple days. I'll give you an executive summary, and trust me, you'll thank me in the morning for not really going into it. It's a horrible thing. I have 5 children, all of whom got the same illness as we progress through the past few days. And let's just say that the illness it's a messy one. It's a messy one. Think of never mind. It's just not pleasant. How's that? And so, on Wednesday night stream, I think, when was that? I think it was Wednesday was when it started. I don't even remember anymore. I think so, yeah. And then Thursday, Wednesday was just 1 kid. And then it was 2. And then sometime Thursday, it became 3. And then Friday rolled around, and which was yesterday. It seems like a year ago. I take 2 of my kids to their camp. They had a camp thing. And their camp is like an hour and a half from my house. And I didn't have to drive them. I just took them to the meeting place, and they drove up, with all their friends and stuff. And so then I get a call about 3 hours later, and I had to go get one of my oldest. I had to go get them from camp because they got the same sickness. And I'm up there and I have a judgment call. And I was my oldest last year in this group at camp. So I was like, he doesn't have any symptoms. He's fine. Let him hang out with his friends. So I just take the second oldest, drive home. And then sure enough, 4 in the morning, 4:30-ish, somewhere around there, Friday, or this morning, Friday night, this morning, I get the call, and I need to drive, another round trip to pick up the oldest. Oh my gosh, it has been a couple days. It has been a couple days. No, it is not the coronavirus. The coronavirus is a respiratory infection. This is not a respiratory infection. It only lasts like a day. It only lasts like a day, and then it's done. But it has just been a mess. So I apologize for the no YouTube streams the past 2 nights. And of course, the Twitch streams being interrupted a couple times. Such is life, man. Such is life. But today, we're going to hit a couple topics at some high levels. We're going to talk. Hopefully, we'll laugh a little bit. We're going to take a look. The most in-depth we're probably going to go is we're going to read through Tulsi versus Hillary. Once I get that thing pulled up. Let me get that pulled up. We're going to look at her lawsuit against the Hill Dog. See if she'll live through the day. See if her lawsuit will survive. Gabbard versus Clinton. Here we go. And then we're going to move through. There's been a development in the Chris Hook case. Not in Chris Hook's part of the matter, right? So I want to be very clear. We still don't know what's going to happen to Mr. Hook, but we do have a huge update on the case itself, which is Baker versus Allstate, I think is the name. Let me hold on, I'm pulling that up too. That's yeah, Alan Baker versus Allstate Insurance. We have a big update in the case there, and so I'm going to give you some commentary and thoughts on it. And I'm sure I'm wrong, right? Because like I'm wrong about everything. But you know, I love the people telling me I'm wrong on stuff. When let's roll that into the preview of the next topic. We're also going to talk about Doucette just for a few minutes, lying pretty brazenly. There's not any action to do with the lie. The guy's just a lying sack of trash, right? He's a lying sack of garbage, and that is plainly apparent. If you haven't figured out that the man is a propagandist for the defendants yet, I don't know what to tell you. He has been from the start. Like, he's pretending online that, I came into this neutral and I just saw it was so stupid. No, not a chance. That would be like me saying that I'm neutral in this. It would be very, very similar. And if you don't understand the lie, imagine the difference. I started a GoFundMe for a specific person, and I have done, like, that GoFundMe has done what it does, right? It's obvious. You know, if you contribute to that GoFundMe, it goes to paying Vic's legal fees. That's it. That's what it's been from the start. Hasn't ever changed. That's where it goes. The money is going there, period. I've been told that not a dime of that will go to see the defendants, no matter what the ruling is. I mean, unless the court were to somehow reverse all course and all logic and try and award them a fee from the GoFundMe. That GoFundMe money is for Vic's legal fees and any excess being donated to Salvation Army, Domestic Women's Abuse Shelter, right? Okay. Domestic Violence Women's Shelter, not Domestic Women's Violence, whatever it is. You know what I mean? Doucette has funded several document purchases, and I have a lingering suspicion, call it a hunch, that he is actually turning those documents over to the defendants. So someone who could ostensibly just be wanting to support the revealing of information would actually be paying the defendants' legal bills unwittingly. But that's just a suspicion. But that being said, Doucette has blatantly mischaracterized a part of the appellate process, and we're going to talk about that. We'll take a look at the rule. It's pretty basic. He should know this, though, right? He's the lawyer who looks things up. So should all of law Twitter. That's how it goes. But so we'll talk about that, and then Meyer versus Wade has had another filing. That is the I don't know that we're going to go through that filing today. It's also, I mean, I haven't read it. I skimmed it, but you know what it is. It's the opposition to the report and recommendation for jurisdiction, just like the previous opposition to the report and recommendation for jurisdiction. So it's the same arguments that we've seen like 5-6 times now. And this isn't a slight on Wade's legal representation. Ryan Pierce drafted the document again. Mark Zaid, of course, is nowhere to be found on this stuff, but Ryan Pierce drafted the document yet again, and he doesn't do bad work. He just doesn't have a good case on jurisdiction, especially. Like the court's decision is pretty solid, but he has to levy his opposition to it to preserve the matter for appeal. So we'll take an overview of that depending on how time is going. But that's where we are today. That's what we're going to go through. We may tangent from here and there, but that's what we're at. And then I'm going to go on Twitch and I'm going to play, you know, Dark Souls until I fall asleep or whatever. I should come up with a Twitch milestone where we do a sleep stream where I just play until I narcolepsy on camera. So, anyway, let's get, where is, that's that one. Is this Tulsi Gap? Let me save this document real quick, and then we'll be on our way. We'll be on our way. Oh, hopefully you guys are having a good weekend so far. I expect mine will be on the up and up from now, or on the up from now on. I think most of the children are through the virus. Although, oh yeah, the reason I was late, you know, we had the baby had a little flare up, but we're good now. Everything's great. Where is? Oh my goodness. I am like fuzzy. You know, did you ever get that fuzzy feeling like I know what I need to do, but everything feels just a little bit far away? That's how I am right now. Why didn't you save the document? Weird. Okay, here we go. Let me get this on screen for you guys. Hey, it worked! Woohoo! You have no idea how excited I am when something just works. And not the Todd Howard just works or whatever. Just, oh my God. What a disaster. What a disaster. No, I don't think I'm getting sick. If I was getting sick, I think I would have had it already. But sleep deprived is right. That's Jack Daniels from last night. Filthy. All right. Let's hit this. I got a chat here waiting. And then we'll get into this document. We've got Mopsink says, question for you, Nick. What whiskey, bourbon, or scotch would you recommend to someone who primarily drinks XO cognacs, but whose pocketbook is begging for it to stop? That's a tough call, man. Because cognacs, yeah. All right. I got you, fam. Maybe. Let me recommend to you an Oban 14-year or a Dalwhinnie 15-year or Distiller's Edition. One of those two. They should be a little cheaper than a cognac. Not a ton cheaper, but they're going to have that wine characteristic. They're going to have, they're going to be a little bit on the sweeter, tart side of things rather than the bitter of whiskey. So there you go. That's what I would do. That's what I would do. Start there. See if you like it. I love both of those, especially that Dalwhinnie. But the Oban's got a little more wine flavor to me. All right. Let's take a, what is this? Go away. Let's take a peek at this document, and we'll get into this. So this is Tulsi Gabbard and Tulsi Now Incorporated versus Hillary, the Hillary Clinton. So we've got, of course, this a delightful lady by the name of Hillary Clinton. Tulsi Gabbard is she still in the race? Apparently, she's still in the race. Let's see. Let's get a Tulsi Gabbard picture up there. For those of you who don't know, Hillary Clinton looks like a corpse. Actually, a defiled corpse. But Tulsi Gabbard doesn't. Some people really, really overemphasize the hotness of Tulsi Gabbard. So, I don't know. You guys can make up your own mind. Oh, here, this is perfect. She's right here. Oh, God. Why the Democratic Party is so fed up with Tulsi Gabbard. This is perfect. This is probably an unbiased article. There's Tulsi, distinguished lady, and she's running for the presidency. But apparently the Democrat Party is fed up with her. I don't know. I don't care about any of these people. I think all of them are pretty much, garbage. So she's hotter than me. I hope so. I hope so. If you thought I was hotter than Tulsi, I would say you were a little late. She's the hottest one running. Yeah, well, that's not hard, right? You've got Bernie. You've got Elizabeth Warren. I noticed in all this impeachment coverage, this is a side thing. I said I might tangent. Every picture I've seen of Senator Murkowski ever is the same face. That same horrified face where the bottoms of her cheek are trying to get away from her eyeballs. She always looks angry. Have you guys, and so many, she redefines the amount of frown lines that a face can have. It's pretty bad. Towers Comics, no! Don't say that. All right, let's take a look at this suit. Plaintiffs Tulsi Gabbard and Tulsi Now Incorporated bring this lawsuit against defendant Hillary Rodham Clinton. Rodham? For defamation. Tulsi Gabbard is running for president of the United States, a position Clinton has long coveted. It's true. But has not been able to attain. So out of the gate, firing. Now it's a bold fire because Tulsi she's got an uphill battle, right? In October 2019, whether out of personal animus, political enmity, or fear of real change within a political party, Clinton and her allies have long dominated. Clinton lied about her perceived rival, Tulsi Gabbard. I'm going to spoil this. I'm going to spoil the whole thing. The spoiler alert. Spoiler alert. This is an ad. This lawsuit's an ad. It's a calculated cost. It's an ad. It's going to read like an ad. It's gonna be full of political puffery. This is a really tough defamation case. Flat out, this is a tough defamation case. All right. That's the long and short of this. I don't know how else to break it to you. This is a hard case for defamation. You've got an unquestionably public figure being accused of something in an offhanded manner. We'll get to the accusation in a minute. And and then the really hard part is damages. Damages is really tough in political sort of things. I would have gotten more votes. I would have gotten more donations. Those sorts of things are real problems. They're not damages the court can typically redress. What's the dollar value of a vote? You can't actually pay someone to make one, right? That's slightly illegal. So, I mean, they do it all the time. Pay people in various ways for votes, right? Welfare's a pay for a vote. The GI Bill's a pay for a vote. Lots of pay for votes. Medicare for all is a pay for a vote. All of this, but Yang is trying to pay people for a vote. All of this doesn't matter. There is no tangible value that the court can put on votes. So there isn't a damage that the court can redress. The court can't force someone to vote for Tulsi Gabbard. That's not a redress that the court can provide. So we'll have to see where they go. That's going to be one of their hurdles. And I'm pretty sure there's a Supreme Court case on this. And I'm going to be doing a summary video of this case that's very, hopefully, as far as I can possibly muster, it's concise. And we'll have the citation to the case, which talks about, yeah, this is something the court can't really fix. Yeah, have I seen Animat's nudes? No. I've seen the screen grabs of his nude YouTube show. Thank God there's no danglies, no dangly bits in the picture. I showed one of them from like the chest up on stream. Just awful. Yeah, I know he called me a psycho, which is weird. I'm not psychotic in the slightest. All sorts of other issues. Vindictive, snide, crude, maybe a tad prideful from time to time. I can think of I've got a list of my own faults. That's what's so great about being self-critical, is that Twitter, has a hard time making fun of you because they're wrong about all the things I'm awful about. I donate them the list, but maybe T. Greg will do a GoFundMe to buy it. Clinton lied about her perceived rival Tulsi Gabbard. She did so publicly, unambiguously, and with obvious malicious intent. Now, how is Tulsi a rival of Hillary? Hillary hasn't announced that she's running. So, how is she the perceived rival? Like, they're framing this as Hillary is the Democrat Party. It's an ad. It's an ad. It's an ad. They're framing this as Hillary is the Democrat Party. Therefore, Tulsi is coming in to bring change like Trump to the Democrat Party. Therefore, Clinton is the Democrats, and the Democrats and Clinton are opposed. And as you saw, that article, which I don't think was from a Republican publication, does seem to suggest some frustration with Tulsi. Tulsi has been harmed by Clinton's lies, and American democracy has suffered as well. Oh, yes. American democracy, suffering left and right. Never-ending suffering. Oh, you're the best.
Figured you meant.
I did. But for later.
Yeah. Baby again. I want to put... Can you have the camera on?
Yeah.
Or is that...
I can. I don't know where it went. I had it pulled up.
I happened here because I was in the kitchen.
I can't have the audio. I can't have the audio on.
Yeah. You could always message me. Fuck.
Well, we'll see. Okay.
All right. Anyway, I just cleaned.
Okay. So I got 30 minutes.
30 minutes.
Guys, it's been a couple days. I'm telling you. There's no other way to put that. It's been trying times. Give me just a second here. I gotta get something pulled up. Oh my gosh. Yeah, this one. Sign in, you horrid thing. Okay, we'll go back to the show here. All right. You want the good sugar cookie? Yeah, these are them, right? Look at these things. Oh, baby. Pink because Valentine's Day is coming up. I'm going to be eating these on the Twitch stream. I'm going to be eating these on the Twitch. Is Lady sick too? Yes, not as sick as the kids got, but yeah, it's been a challenge. Okay, here we go. With this action, Tulsi seeks to hold Clinton and the political elites who enable her accountable for distorting the truth in the middle of a critical presidential election. Nature of the case, Tulsi Gabbard has lived her life with one guiding principle. It's an ad, it's an ad, it's an ad. Putting the needs of others before her own. That's why Tulsi joined the Army National Guard. That's why she campaigned for and was elected to the United States House of Representatives. And that is why Tulsi Gabbard is running to be your president. Living by this principle, Tulsi has put the country's needs above all else. All else, even when it means hurting her political career. For example, in February 2016, Tulsi believed the best Democratic presidential candidate for our country was Senator Bernie Sanders. She also knew that Clinton had a stranglehold over the Democrat Party, literally, and that crossing Clinton, who considered herself to be the inevitable nominee, could mean the end of her own political career. Yet Tulsi put the country before herself, and she publicly endorsed Senator Sanders, becoming the most prominent politician to do so at the time. Clinton, a cutthroat, literally, politician by any account, has never forgotten this perceived slight. And in October 2019, she sought retribution by lying publicly and loudly about Tulsi Gabbard. Honestly, it wasn't that loud. Never heard it until the lawsuit. Didn't hear about it. Now I don't focus on the political, I don't focus on the election that now starts in 2019 for 2020, that now starts halfway through 2019. I just can't wait till we're campaigning for the next president. That's when we'll be at peak America. That's when we'll be at peak America, is when we're campaigning for the president 5 years out. Specifically, in widely disseminated national comments, Clinton falsely stated that Tulsi, an Army National Guard officer and United States Congresswoman who has spent her entire life serving this country, is a Russian asset. Now, to be fair, that's the perfect Russian asset. I mean, I'm not saying that there's any credence to this, but if you're going to have a foreign asset, you would want to have one who looks all American. That was the whole point. That's what they did back in the 50s. Clinton's false assertions were made in a deliberate attempt to derail Tulsi's presidential campaign. Clinton had no basis for making her false assertions about Tulsi, and indeed, there's no factual basis for Clinton's conspiracy theory. Clinton's peddling of this theory has harmed Tulsi, has harmed American voters, and has harmed American democracy. Tulsi brings this lawsuit to ensure that the truth prevails and to ensure this country's political elites are held accountable for intentionally trying to distort the truth in the midst of political, in the midst of a critical presidential election. Parties. Tulsi Gabbard is a natural person. I think that's a slight at Hillary right there. Oh no, they call her a natural person too. Dang it. They shouldn't have. They should have said Tulsi Gabbard is a natural person, and they should have said Hillary Clinton is a person. That's what I would have done. Tulsi Gabbard is a natural person who is a citizen and domiciliary in the state of Hawaii. Tulsi now is the presidential campaign committee for Tulsi Gabbard. Tulsi now is incorporated in Delaware with his principal place of business in Hawaii. Excuse me. For the purpose of Tulsi's presidential campaign, Tulsi Gabbard and Tulsi Now are essentially synonymous and operate in sync. Gabbard cannot run for office without Tulsi Now, as Tulsi Now is the entity required for receiving, processing, and handling all contributions to her presidential campaign. Clinton is a natural person who is a citizen and domiciliary of the state of New York. Jurisdiction. So this is federal diversity jurisdiction. That means that you have to have all of the parties have to be completely diverse. And that's their domiciliary and principal place of business. So in this case, Tulsi's in Hawaii, Clinton's in New York. That's diversity. Tulsi Now is in both Hawaii and Delaware because it's incorporated in Delaware, but the principal place of business is Hawaii. So they get 2 states of jurisdiction for the purpose, or 2 states for the purposes of diversity jurisdiction. But they are still completely diverse. Now, had Tulsi Now been incorporated in Delaware and having a principal place of business in New York, for example, then Clinton and Tulsi Now would not have diversity, and therefore you have to have complete diversity between the plaintiffs and the defendants. So that's subject matter jurisdiction. The next part of that, that's diversity jurisdiction. The next part of the jurisdiction is the subject matter, and in this case, they're citizens of different states. That's in Article 3. And the amount in controversy exceeds $75,000 exclusive of interest and costs. So it has to be at least $75,000.01. If it's exactly $75,000, you have to file in state court. The federal court won't have jurisdiction. So, of course, it's more than... Doesn't matter what it is. You have to make a good faith claim that it's over 75,000. It's really hard to disprove, but here we go. Venue is proper because Clinton resides in this district and because a substantial part of the events giving rise to this complaint occurred in this district. So she brings it to Clinton's district. This way we hopefully avoid the cluster that is Meyer versus Wade, right? Meyer has to bring Wade into federal court in Texas from California. It creates a whole lot of opportunities for them to say, nuh-uh. But in this case, the New York District Court is going to have jurisdiction over Hillary Clinton because she lives there. So she's subject to the court's jurisdiction already. So it eliminates some of those arguments. Thedia says Clinton body count versus Poo Flu body count. 2020's UFC lineup is amazing. All right, factual allegations. Background. If you weren't ready for an ad break, here's another ad break. Tulsi is a 4-term United States Congresswoman, a major in the National Guard, and a military combat veteran of Iraq. Tulsi is running for president of the United States as a member of the Democratic Party. Tulsi's presidential campaign is a culmination of a long career of public service and desire to step up when called upon for duty. As a child, Tulsi's parents would enlist her and her siblings in service days, where the family would pick up litter from beaches or prepare food for homeless families. At the age of 21, Tulsi began serving in the Hawaii state legislature. Motivated by the terrorist attacks on September 11th, 2001, hashtag never forget, Tulsi made the decision to dedicate her life to protect the safety, security, and the freedom of the American people. She enlisted in the Hawaii Army National Guard. In 2004, as Tulsi was campaigning for re-election to the State House, the Hawaii National Guard's 29th Brigade Combat Team was called up to deploy to Iraq. Tulsi's name was not on the mandatory deployment roster, but she knew there was no way she could stay behind as her brothers and sisters in arms were sent off to war, possibly never to return. So Tulsi left an easy re-election campaign and volunteered to deploy, the first of 2 deployments to the Middle East as a soldier. Between tours of duty in the Middle East, Tulsi worked in the United States Senate as a legislative aide to Senator Danny Akaka, where she focused on veterans issues. But it's always always the country's needs above her own. Sorry, that's cynical. That's cynicism right there. Like, that's one of the most self-serving issues she could have. Not that veterans issues don't need attention. I'm just saying, after 2 deployments, Tulsi returned to Hawaii to serve on the Honolulu City Council. And today, Gabbard continues to serve. Now as a 4th-term United States Congresswoman and as a major in the National Guard with 16 years of service. Hillary Clinton. Clinton was a 2016 Democratic Party nominee for President of the United States, the United States Secretary of State from 2009 till 2013, a United States Senator for the state of New York from 2001 to 2009, and the First Lady, sort of the United States from 1993, but not the second or third, am I right? Clinton also ran for president in 2008, but she failed to secure the Democratic Party nomination. In both the 2008 and 2016 presidential elections, Clinton was the clear frontrunner, but she ultimately lost in surprise upsets. No one is surprised. They're like, literally anybody? Is there no one else? Anybody? Please? Somebody other than her? Anybody? First to President Barack Obama in the 2008 presidential primary, then to President Donald Trump in the 2016 presidential election. Clinton's defaming Tulsi, the only person with a lower likability rating than Trump going into the 2016 election, was Hillary Clinton. Like, that's great. For all of the crowing about how unlikable Trump is and how his approval rating is low, Clinton's was worse. Okay. Clinton's defamatory statements. On October 17th, 2019, Clinton was a guest on the podcast Campaign HQ with David Plouffe. In the course of a widely distributed national interview, Clinton stated the following regarding, quote, somebody who is currently in the Democratic primary who, quote, they are grooming to be the third-party candidate. So that's how she identified this person. And then, quote, she's the favorite of the Russians. They have a bunch of sites and bots and other ways of supporting her so far, and that's assuming Jill Stein will give it up, which she might not because she's also a Russian asset. Yeah, she's a Russian asset. Now, in fairness to Hilldog, the way this reads, she could be talking about Jill Stein, but I believe it's clarified that she's talking about Tulsi in a little bit. Okay. Footnote 1, precisely whom Clinton asserted is grooming Tulsi has been disputed by Clinton's allies. The grooming dispute is a red herring, as this complaint, which precisely identifies Clinton's defamatory statements, makes clear. All right. Campaign HQ with David Plouffe is a popular and prominent political podcast. The podcast is hosted by David Plouffe, President Barack Obama's former campaign manager. Campaign HQ with David Plouffe has a large audience and is available for streaming through Apple Podcasts, Stitcher, Radio.com, and Player FM, amongst other places. The podcast is produced and hosted by Cadence 13, a company valued around $50 million. The next day, October 18th, Clinton doubled down on the defamatory statements. A CNN reporter asked Clinton's official spokesman, Nick Merrill, whether the defamatory statements were about Tulsi. Clinton's spokesman responded, if the nesting doll fits, he continued, this is not some outlandish claim. This is reality. And again, I mean... if the nesting doll fits is a joke about Russians, right? Russian assets. He doesn't say yes here. This is not some outlandish claim. This is reality. I mean, that's them trying to make it a factual statement, sort of. Clinton's reference, which is actually Nick Merrill's reference, to he is a spokesperson for the campaign, but still, it's not her, right? Clinton's reference to the nesting doll is a reference to the universally known Russian nesting dolls, Matryoshka dolls. Matryoshka? If it's universally known, why did you write it in the complaint? Clinton's defamatory statements immediately harmed Tulsi. Despite reprobation of Clinton by several 2020 presidential candidates, including Senator Bernie Sanders, Marianne Williamson, and Andrew Yang, for her baseless conspiracy mongering, Clinton's defamatory statements spread like wildfire across the internet and took on a life of their own. Millions of Americans heard or read about a well-known authority figure, Clinton, Is she a well-known authority? Does anybody think Clinton is an authority figure? Oh my gosh. Stating as fact that Tulsi was a Russian asset and the favorite of the Russians, scientifically conducted opinion surveys have shown that Clinton's false, malicious statements about Tulsi were accepted as true by millions of Americans, including large numbers of voters in battleground presidential primary states. Scientific polling. Again, this is a hard part of the case. I said earlier, opinion polling. Okay, how does this translate into a defamatory claim the court can provide redress upon? What are you going to do? In short, Clinton got exactly what she wanted by lying about Tulsi. She harmed her political and personal rival's reputation. An ongoing presidential campaign started a damaging whisper campaign based on baseless but vicious untruths. Clinton refuses to retract the defamatory statements. Despite calls from Tulsi and other public figures to correct the record, Clinton did not retract the defamatory statements, nor did she apologize for them. Before bringing this lawsuit, Tulsi wrote to Clinton and advised her of the complete and total falsity of the defamatory statements. Tulsi also asked Clinton to retract the defamatory statements. Clinton refused to retract the statements and instead stood by them. She continues to stand by them. She refuses to apologize, and Tulsi continues to be greatly injured. The defamatory statements are false and defamatory per se. The defamatory statements expressly stated and specifically conveyed that Tulsi, a U.S. Congresswoman, presidential candidate, and major in the United States Army National Guard, is a Russian asset. The ordinary and average person who heard and read the defamatory statements understood them to be making serious charges against Tulsi, that Tulsi is a tool of, and perhaps an agent of, the United States geopolitical rival Russia. I take umbrage with this being included. If Tulsi is a tool of Russia, she could be an unwitting tool. If she's an agent of Russia, she's an asset. I think typically when we're talking about assets in the national security sense, we're talking about agents of a foreign power, an asset, an intelligence asset, something like that. Reducing it to just being a tool, I think, takes it away from being defamatory per se on the face of their own complaint, and that's a problem for them. If it's perhaps an agent of, JFK was undoubtedly a tool of Khrushchev, right? Undoubtedly. Was JFK an agent of the Russians, of the Soviet Union? Well, no. He was a tool of them. Khrushchev wanted JFK in office. Khrushchev worked to have JFK brought into office. The Russians interfered with the U.S. presidential campaign by doing all sorts of things, running ads and stuff like that to get him into office. He was a tool of the Soviet Union. But he certainly doesn't appear to have been an agent of the Soviet Union. So there's a big difference there. Big difference. The defamatory statements indisputably were made about and concerned Tulsi. I don't know if that's indisputable. As much is clear from the words of Clinton's own official spokesman on October 18, 2019. See, and I take issue with that. If the nesting doll fits is you're saying it, I'm not saying it. You're saying it, right? If you think so, if the evidence is lining up for you, well, then that's what, right? He's inviting, and I don't like Clinton. No, not a lick of like for her. I would probably much rather be trapped in a room with Tulsi Gabbard than Hillary Clinton, because I know that Tulsi Gabbard isn't going to drain the life essence out of me and leave me as a withered husk to rejuvenate 20 more minutes of her life before bathing in the blood of the unborn, right? Like, I know that Tulsi probably isn't going to do that to me, and Hillary will. I have no reason to defend Hillary at all. But these statements are not as explicit as they're making them out to be. I did check the baby monitor. Anyway, let's see. as well as from innumerable media reports interpreting the defamatory statements as concerning Tulsi. Americans throughout the country interpreted Clinton's defamatory statements exactly as they were intended to be interpreted, as referring to Tulsi and stating as fact that Tulsi was a Russian asset. Defamatory statements implicitly conveyed additional information. The ordinary and average person who heard and read the defamatory statements understood them to mean that Tulsi was in general sympathy with Russia's aims, objects, and methods. That's not illegal. They also understood them to mean that Tulsi was aligned with Russia, not the United States, which could be illegal, and would act to further Russia's interests in this presidential election. The ordinary and average person who heard and read the defamatory statements also understood them to be statements of fact. Statements use specific language with a precise meaning, even though it's not that precise, is it? You just said right here, perhaps an agent of. That's imprecise. Is a tool of, and perhaps an agent of, that's imprecise. That is capable of being objectively characterized as true or false. And the statements were not if she's just a tool of it, were conveyed in a tenor of complete sincerity as conveying facts and not opinions. The ordinary and average person who heard and read the defamatory statements understood them to impute Tulsi with a lack of fitness for her office and profession, both in her political office and candidacy and in her position as an officer in the Army National Guard. That, I think, is correct, that they did that. That's the meaning of it. They understood the defamatory statements to mean that Tulsi was assisting the Russians, their asset, potentially even as a Russian agent and traitor to this country, which is widely understood meaning of Russian asset. Potentially, if it's widely understood, then you don't need to say potentially. Why is the lawyer suing on behalf of Tulsi Gabbard not just flat out saying Clinton meant she was a Russian spy? Obviously, asset means spy, agent, traitor, all of those things. That's what she meant. Why are they weakening this with potentially? There's no reason to. This is a complaint. It's weird. The ordinary and average person who heard and read the defamatory statements additionally understood them to be statements of fact because Clinton portrays herself to the public as the flag bearer for ensuring that truth prevails in speech related to politics. She doesn't do that very well. Who believes that Hillary Clinton is a banner and bastion of truth in politics? Does anybody on earth believe that? As the Democratic Party's presidential nominee in 2016, a former Secretary of State, a former U.S. Senator, and former First Lady, Clinton is widely perceived by the public as someone who would therefore know if Tulsi or anyone else were a Russian asset. Oh, wait. I skipped a whole line. Public as someone who would have access to information and intelligence not available to ordinary Americans, and who would therefore know if Tulsi or anyone else were a Russian asset. Not only that, but Clinton has campaigned for stopping false and misleading statements by election campaigns. She portrayed herself as a neutral third-party observer. These were not statements by someone who is well known to speak in hyperbole. Come on. They're just trolling at this point, right? The defamatory statements are materially false because they would have a different effect on the mind of the listener or reader from that which the truth would have produced. Tulsi is not a Russian asset. Oh, thank goodness. No one, Russia or anyone else, controls her or her presidential campaign. Instead, Tulsi is a loyal American servant, declaring her allegiance to the United States of America both as a soldier and a member of Congress. She's been serving for over 16 years in the U.S. Army National Guard, has voluntarily deployed twice to war zones in the Middle East. At Russia's behest. I'm just kidding. The defamatory statements are defamatory because they tend to lead the average person in the community to form an evil or bad opinion of Tulsi, as well as because they tend to discredit Tulsi in the conduct of her occupation, profession, and office. Defamatory statements accusation is devastating to United States politicians' reputation. It didn't work against Trump. That should be Clinton. Clinton should come out. Yeah, I said it. And I meant it. When I said it about Trump, he got elected. I'm trying to help Tulsi. How could this possibly hurt her? All evidence points to her being elected if I keep this up. She should just rub herself down with Cheetos and she'll be fine. During the 2016 presidential election, state-sponsored content farms sought to interfere with the U.S. presidential elections. The issue of foreign interference in U.S. elections is an important concern that is treated seriously, as Americans as a whole do not want any other country interfering in their elections. The ordinary and average person who heard and read the defamatory statements understood them to be stating that Tulsi's candidacy is part and parcel of Russian efforts to interfere with the 2020 presidential election. Americans do not want to support Russian interference in the 2020 presidential election. Do you have scientific polling data on that? And because Clinton maliciously lied. That's a conclusory statement, by the way. This is, at this point, it's conclusory. But we've got a segment coming up on actual malice, so we'll see how they lay it out here. Many Americans now associate Tulsi with such foreign interference. In short, Clinton has, to date, gotten exactly what she wanted by spreading malicious lies about Tulsi through the defamatory statements. She's greatly harmed Tulsi's presidential campaign. Clinton made the defamatory statements with actual malice. Clinton knew that the defamatory statements were false and she published them knowing they were false. Clinton also intended the defamatory statements to be defamatory and endorsed their defamatory nature. At the very least, Clinton acted in reckless disregard of the truth or falsity of the defamatory statements when she published them. As a former United States Senator and Secretary of State, and not just an ordinary American, Clinton had reason to know that the defamatory statements were false. She had no facts backing up her defamatory statements, including her claim that Tulsi was a Russian asset. In fact, Clinton had access to a surfeit of reliable, I don't even know how to pronounce that, surfeit? Of reliable information to the contrary. How do they know? They actually don't know this. So far, I'm not impressed with their actual malice claim, but we'll get there. Wait, are we judging this by real people standards or by law Twitter standards? For example, no United States law enforcement or intelligence agencies have claimed, much less presented any evidence, that Congresswoman Gabbard is a Russian asset. As a member of the House Armed Services Committee, Foreign Affairs Committee, and Homeland Security Committee, as a major in the United States Army National Guard with access to highly sensitive and classified information, Tulsi has never had her security clearances challenged or revoked. Clinton, a former United States Senator and Secretary of State, certainly knows and knew at the time she made the defamatory statements that if Tulsi was truthfully a Russian asset, she would not have been in these positions of great responsibility with access to the most sensitive national security information and working closely with officials at the highest levels in the United States military, including the commander of the United States Pacific Command. Actually, that's a weird statement because we have found foreign agents in all of these positions that they talk about. What kind of silliness is this? That's what a spy is. That's what a spy is. I talk about Malcolm Gladwell a lot as a recommendation for a good podcast. Revisionist History is a good podcast. If you like well-produced podcasts with interesting topics and guests, it's a great one. Malcolm's book, his most recent book, is an audio book only. But I think you can buy a copy of it. I don't know. But I highly recommend, and you can do this part for free. You can find the Revisionist History episode, which is the one chapter. Go listen to the chapter called The Queen of Cuba. Okay? Read Malcolm Gladwell's, or listen to Malcolm Gladwell's chapter called The Queen of Cuba. And this entire paragraph makes no sense. I mean, this is a person working at the highest level of government, in intelligence, in the Situation Room in the White House, who is a Cuban spy. Like, of course we have Russian spies at high levels. Of course we have foreign spies at high levels, because that's where they would go. They're not going to be loading up shells in the ark. Actually, they will be there also, probably. But like, the higher value assets are going to be higher and higher levels of the government. That's what they do. This is a silly statement. Rather than facts or reliable evidence, Clinton's basis for the defamatory statements was one of both of her own imagination or extremely dubious conspiracy theories that any reasonable person, and especially Clinton, a former United States Senator and Secretary of State, would know to be fanciful, wholly unverified, and inherently and objectively unreliable. Ooh. In view of Clinton's personal and professional history, there is no other reasonable inference but that Clinton, at minimum, made a deliberate decision not to acquire knowledge of facts that might confirm the probable falsity of the defamatory statements and purposefully avoided the truth. But the most likely inference is that Clinton intentionally lied to harm her perceived personal and professional rival, Tulsi. Now, this is interesting. Again, in comparing this to the Vix case, this is a statement of a prima facie statement, right? And according to a lot of people on the internet, which I don't actually agree with, is wholly insufficient to make a prima facie claim. I think that this is a very good section right here. This is a good section about reckless disregard for the truth or intentional falsity. But see, I don't think that this is going to hold up in the long run, but I think for making a prima facie statement about the acting with actual malice, that this is a pretty well drafted chunk of this. Actual malice is further demonstrated by the defamatory statement's inherent improbability. I don't know that they're inherently improbable. Tulsi is a 4-term sitting United States Congresswoman. She's a major in the United States Army National Guard. She is a loyal American who has taken an oath declaring her allegiance to the United States of America, both as a soldier and a member of Congress. Tulsi has been serving for over 16 years in the Army National Guard. Have you guys memorized this yet? Have you memorized this part of the ad yet? Having voluntarily deployed twice to war zones in the Middle East, she's the vice chair of the Democratic National Committee. Oh, she's definitely a Russian asset. And she is a candidate for the president of the United States. Given this, Clinton would have known there was no basis for her defamatory statements, including her claim that Tulsi is a Russian asset. Actual malice is also demonstrated by Clinton's refusal to retract the defamatory statements. Before filing this lawsuit, Tulsi sent Clinton a letter explaining why the defamatory statements are false and defamatory and demanded their retraction. Clinton has refused and continues to stand by the statements. Clinton purposefully avoids and recklessly disregards information demonstrating the falsity of the defamatory statements. This is not how you demonstrate actual malice, but I mean, toss it in there. Actual malice is further demonstrated by Clinton's ill will against Tulsi. Tulsi broke ranks from the DNC and backed Senator Bernie Sanders against Clinton in the 2016 presidential election. Clinton has not gotten over her loss in that election, still dwells on what happened. True. Clinton blames many persons for her loss. True. One of them is Senator Sanders, whom Clinton blames for being late to endorse her in the 2016 campaign. But Clinton reserves a special hatred and animosity for Tulsi, who never endorsed Clinton, did not campaign for her, and to top it off, gave the nomination speech for Senator Sanders at the 2016 Democratic National Convention. How? I mean, she's saying that Clinton hates her. I get it. But how? How do we know this? Where do we verify this? In February 2016, Tulsi was vice chair of the DNC. She publicly backed Senator Sanders over Clinton for president, and she was the highest profile congressperson to do so at the time. Clinton was extremely angry, to put it mildly, that Tulsi endorsed Senator Sanders over her. Clinton's agents emailed Tulsi to tell her that the Clinton team no longer trusts Tulsi's judgment, and Tulsi was told that the Clinton team would never forget this slight, among other things. Just sent a bunch of links to Seth Rich's Facebook profile. Among other things, Clinton's agents relayed that the Clinton team will refuse to assist Tulsi in any of her campaigns. These agents then forwarded this correspondence to Huma Abedin, Clinton's closest aide, and John Podesta, chairman of Clinton's 2016 presidential campaign, an all-around weirdo, to gloat about the beatdown they felt they delivered to Tulsi, writing, "Hammer dropped." It has been widely reported by news sources that Clinton is known to keep longtime grudges, even going as far as maintaining for me and against me databases. They were all purged, though, and scoring degrees for treachery for those that have crossed her. I believe that 100%. 100%. This ill will is further demonstrated by vitriolic comments by Clinton through her spokesman Merrill about Tulsi. In one public comment on October 10th, 2019, Clinton's spokesman said that he was seriously considering watching the presidential debate if Tulsi promised that she would not be there. That's kind of funny. That's about as funny as politicians tend to get. In short, Clinton has a unique personal connection to Tulsi that animates her hostility towards Tulsi in her presidential campaign. The defamatory statements were republished by many media outlets and disseminated widely. This isn't an element of defamation. I guess they're going to try and tie this into the damages element, which they haven't explained damages yet, so I'm looking forward to that. The press extensively covered the defamatory statements, publishing more than 200 articles about the defamatory statements, putting aside the significant airtime devoted to the subject. News companies reporting on the defamatory statements include ABC, the Associated Press, CBS News, CNN, Fox News, NBC, New York Times, and the Washington Post, among others. This reporting interpreted the defamatory statements just as the ordinary and average audience member did, that Clinton was asserting that Tulsi was a Russian asset and that her presidential candidacy was part and parcel of Russian interference in the 2020 U.S. presidential election. Some articles affirmatively called out Clinton for peddling a reckless conspiracy theory that had no factual basis, but as noted earlier, Clinton's own spokesman rejected this criticism and declared Clinton's Russian asset assertions as fact. They damaged her reputation. Oh, thank God. The defamatory statements injured Tulsi's reputation. As a direct and proximate result of Clinton's intentional and malicious misconduct, Tulsi has suffered anguish and damage to her reputation, with direct and substantial injury to her positions as United States Congresswoman, presidential candidate, and officer in the Army National Guard. These substantial injuries are continuing in nature and will continue to be suffered in the future unless and until they are remedied by this court. This entire paragraph is completely conclusory. She suffered damage is not her suffering damage. She is still a U.S. Congresswoman. She is still a presidential candidate, and she is still in the Army National Guard. She's still an officer. She wasn't demoted. She wasn't suspended. None of those things stopped. She wasn't given sanction by the House of Representatives. Nothing has happened to her. She's just said that she's gotten direct and substantial injury. This is conclusory. This entire paragraph is meaningless. Millions of Americans heard or read about Clinton's defamatory statements. Scientifically conducted opinion surveys. What a stupid phrase. Have shown that Clinton's false, malicious statements about Tulsi, including that Tulsi is a Russian asset and the favorite of the Russians, were accepted as true by millions of Americans, including large numbers of voters in battleground presidential primary states. Remember that something like 20 million Americans believe the moon landing was faked in a Hollywood studio, for example. Millions of Americans is not hard to achieve. Plus, in this state, it's the Democrats, so they count the illegals as well. That's a joke. It's a joke right there. The defamatory statements have caused Tulsi to lose potential donors and potential voters who heard the defamatory statements. Tulsi has suffered significant actual damages personally and professionally that are estimated to exceed $50 million and continue to this day. That's going to be tough. That's the closest thing they have to a statement of damages. And I feel like there's a Supreme Court case on point that says potential political endorsements aren't damages because they can't quantify them. Can't possibly do it. First cause of action, defamation. Defamatory statements were defamatory per se. They had a tendency to expose Tulsi to public hatred, contempt, ridicule, or disgrace. Defamatory meaning is clear without reference to extrinsic facts. Are you sure? The defamatory import is apparent on the face of the defamatory statements. The defamatory statements falsely impute Tulsi with a lack of fitness for her office and profession. That's an element of per se defamation. Defamatory statements would tend to harm and indeed have harmed Tulsi in her office and profession. Haven't said how. They haven't said at all how in her office and profession she's been harmed, both politically and military. and they have assailed her integrity. The defamatory statements tend to expose and indeed have exposed Tulsi to contempt, ridicule, aversion, or disgrace. The defamatory statements falsely impute criminal conduct to Tulsi. Defamatory statements concern Tulsi. They were reasonably understood to be about Tulsi. The reading and listening public would have understood and did understand the defamatory statements were of and concerning Tulsi. Clinton published the defamatory statements. She communicated the defamatory statements to someone other than Tulsi, and Clinton intended that the defamatory statements be distributed widely to the American public. These are just the elements of defamation, right? This is a publication element to a third party about an identifiable second party. Defamatory statements were false and substantially untrue. They were materially false. When Clinton made the defamatory statements, she knew they were false or acted in reckless disregard for the truth. No applicable privilege or legal authorization to publish the defamatory statements, and they were a substantial factor in causing Tulsi to suffer economic loss in an amount to be proven at trial. At present, actual damages are estimated at $50 million and counting. In addition to actual damages, Tulsi is entitled to appropriate special and punitive damages in view of Clinton's malicious and unrepentant conduct. The amount of these damages will be proven at trial, but in no event should they be less than the amount of Tulsi's actual damages. There you go. We ask for award of compensatory, special, and punitive damages in appropriate amounts, injunctive relief prohibiting the publication or republication of the defamatory statements. They're already out there, and they can't enjoin the world from publishing, just Clinton. An award of Tulsi's costs associated with this action, such other and further relief as the court may deem just and proper. So there you go. That is Tulsi versus Clinton. It's an ad. It's an ad. That's where it is. It's an ad. I don't know how else to say it. Like I said, I'm going to put together a short video on this that'll focus specifically on the allegations, on the damages section of it, and then I'm pretty sure there's a Supreme Court case on point. Couple things to cover though. So TCPA, anti-SLAPP, stuff like that. Those are procedural motions, and those are done under the laws of the state. So they would be under New York's anti-SLAPP provisions. New York has a very weak anti-SLAPP law. So there won't be there likely will not be any sort of anti-SLAPP motion on this, although you can expect what would be called a 12B6 motion to dismiss, which would be failure to state a claim or cause of action upon which relief could be granted. It's similar to an anti-SLAPP motion in the fact that it is a motion to dismiss. It says that on the face of the document, there's not enough to go forward. There's no actionable claim, and therefore it should be dismissed. The anti-SLAPP laws tend to just add stuff to the already existing dismissal remedy, like automatic payments for the fees of the plaintiff, or the fees being paid by the plaintiff to the defense if the defense should ultimately prevail, stuff like that. In Texas, of course, the discovery stay goes into effect because discovery is the most expensive part of a lawsuit. Typically, that's what they have here. So in this case, we're likely going to see a 12B6 motion to dismiss. We won't, we'll have to see what arguments Hillary decides to put up on it. But long and short, I think this is a very they're trying, but I think it's an ad. It's a low risk ad, pretty minimal cost to draft up the complaint, get it out in the news cycle, show that and this is important, right? Tulsi is showing that she opposes this. She's saying that it's false, it's materially false, and she's fighting against it. And if Clinton comes out and wins on a procedural motion rather than on the substance of the claim, then Tulsi has made a good showing. She can say, look, we fought it, but the nature of defamation law as a public figure, specifically one who's running for president, is really, really hard to win. So, we lost on the procedural grounds, but Tulsi Gabbard maintains that she's not a Russian asset. she's put a thing out there. She's repudiating it, and that's what's kind of important here. The public image of this lawsuit is more important than the victory of the lawsuit. It's more important than anything else, frankly. She's just got to come out and oppose it in a way that's not just her getting into a flame war with Hillary Clinton on the news channels. That doesn't benefit anybody. So she files a lawsuit, says, we'll let the courts decide. I'm going to focus on my campaign. This is all false. This thing's not going to get resolved before the election anyway, so, unless it gets dismissed straight out by Clinton. But it's not going to get resolved before the primaries. And that's probably the important part. So there you go. There you go. That's Tulsi versus Hillary Clinton. We will have to see how many masked men start hovering around in the background of Tulsi Gabbard pictures and see if she falls down any elevator shafts to land on a bunch of bullets. Let's see. Next. I mean, if anybody has any last questions on Tulsi, there you go. But I want to move on to Chris Hook. And again, Hook. This is not about Chris Hook's part of the Allstate case. This is just a couple little blurbs about this. Let me get this pulled up here. Just a minute. Why not? Oh my God. All right. Oh, come on. Here we go. Let's see. Got a couple Chris Hook documents here. If you remember last time where we left off, let's see. It was Chris Hook's attorney saying that, hey, the $40,000 is a little bit much. They asked for like $6,000. That's what Hook agreed to pay. That's what he should pay, if anything. He actually shouldn't even pay that, but if anything, that's what he should pay. So we've got a reply brief to go through real quick. And I'll pull that up here. And then we've got that. But then more importantly, we'll cover the more important thing first. We've got an update in the case itself. Oh, this isn't that spicy. Don't get your hopes up. All right. Okay. Let's pull. What? Oh my goodness. How annoying. Sorry. Yes. Here we go. Are you not gonna work? Oh my gosh. Okay, we'll do it this way. Okay. Oh, you know what? Sorry. I'm remembering I can just do it this way. Brain work hard. Okay. Here we go. Where? Oh my gosh. All disorganized. That one. Well, what do we have here? What do we have here? Notice of conditional settlement. Notice of conditional settlement. To the court and all parties and attorneys of record, please take notice pursuant to Local Rule 40-2. The parties have reached a conditional settlement in principle of the case. The deadline to fulfill the settlement terms will be 15 days after execution of a settlement agreement, which is yet to occur. Once the settlement terms have been fulfilled, the parties will submit a stipulation for dismissal of the case with prejudice. Now, there is a chamber order issued following this that the parties have until February 2nd to file their settlement agreement, basically, or file notice of a confidential settlement agreement. One of those two things. They have to do it properly. But how interesting is that? I mean, to me, it's very interesting. And let's review why it's very interesting. So, if you remember, Chris Hook is an attorney representing a couple against Allstate. Allstate, who allegedly was the insurer for the couple. The couple had some sort of loss in their house, and Allstate refused to pay out the agreed upon insured amount, right? Their policy amount. And they were fighting over that amount. Chris Hook got 2 depositions, one from the adjuster and one from like the manager of the local Allstate branch or whatever. And following those depositions, Chris Hook got so confident that not only would he win at trial, but that he would win punitive damages with an obscene price tag. Because again, you have to dissuade a major insurance company from making the same sort of error. That's what the punitive damage would have to be. It would be reasonably calculated to dissuade Allstate, a massive insurance company, from similarly screwing over someone else in the future. So the amount has to be high. Necessarily, it has to cause them an amount of pain. $100,000 to Allstate, whatever. Like they're paying that out every hour. They don't really care. They're making more than that every half hour, right? That's how the insurance companies work. So it's got to be a big punitive amount. So Chris Hook starts emailing them, demanding settlement, saying, I am going to absolutely violate your corpse at trial. That's not what he said, but that's what he implied. And that settlement or that punitive amount's going to be huge. They didn't respond to him, and then he started firing off on them and increasing the amount of settlement and all of that stuff. Very, very cocky. Now, what Allstate tried to do, Allstate tried to then go in and get the entire case dismissed because of Chris Hook's conduct. That was their first thing. If we can get the entire case thrown out because Chris Hook's conduct is bad, his lawyers asked him to do bad, or not his lawyers, his clients asked him to do bad, and they knew about it, and they're all mean, and they're all bad people to poor little innocent Allstate, who can't even defend herself. She's just a 6-year-old girl, Allstate Insurance Company, and what are they supposed to do? What are they supposed to do? Please. So they asked to dismiss the entire case because of the rampant, abusive, and vile threats of violence from Chris Hook, right? They also demanded Hook's removal as an attorney from the case, and they demanded Hook's removal from life in principle, not in reality. And they similarly moved the court to offer a permanent injunction on the depositions of anybody, because anyone who is going to deposition for Allstate was going to be maimed murdered, waterboarded, all of those things, probably in different orders. That's what they said. Now, after that, Chris Hook was fired as counsel by his clients. Whether or not that's the case, that's the truth of the matter, is that he was terminated as counsel. Or I shouldn't say whether or not that's the case. It is the case. Whether or not it happened as described, where they found out, were appalled and terminated him, might be true. Or it could be true that he said, look, guys, I got to get out of here or else your case is toast. Either way, he's out. That moots most of the issues. And most importantly, the only right things the judge did in this case is the judge said, I'm not dismissing the case, and you don't get protection from the depositions. They can call you back for depositions. Once that's done, Allstate settles really quickly. And that is very, very interesting. That is very, very interesting. It tells me that Chris Hook definitely had something in those depositions that he was latched onto. He's confident in victory. Allstate was throwing the Hail Mary, right? This guy screwed up. We can throw a Hail Mary pass. If the judge takes it our way, we get out of this case. We get it dismissed and we win. If not, gonna have to settle. Gonna have to settle. Now, of course, we don't know what the settlement terms are. They haven't actually filed settlement. Likely they won't. Likely they would file a confidential notice, just saying that the matter is settled and requesting the court to dismiss it with prejudice, probably with costs and fees being borne by the parties themselves. And that'll be that. That'll be all we'll ever see of that settlement, most likely. Most likely. But man, it sure looks like Hook had him. It sure looks like Hook had him. So I found that very interesting to see just how quickly they folded. I mean, they folded fast after the judge kept the depositions and kept the case in court. So I wanted to share that with you guys. We're still waiting to see what the judge decides. Like I said, Chris Hook had asked the court to only do about $6,900 in fees, 62. I don't remember the second number. In the sixes, in the 6,000s for fees. That was originally requested by Allstate. Then Allstate submitted their fee brief and asked for 41 grand instead of the initial 6. Hook opposed any of it, but did in principle state that he agreed to pay the 6,000 or whatever. Because when he was in court, he said, I agree, I should have to pay them or blah, blah, blah. But he didn't agree to paying them 40 grand. That's just ridiculous. All right. So here is Allstate's response to that, though. From reading Chris Hook's response to Allstate's memorandum of costs, one might think that as soon as Allstate filed its ex parte application, Hook immediately withdrew his counsel, agreed to halt all depositions, and apologized to Allstate's lawyers for his slurs and threats of physical violence. But nothing could be further from the truth. Far from withdrawing, Hook opposed the application and fought tooth and nail to stay in this case. No, he fought to keep his client's case alive. Like, that's what he did. Until they found new counsel. That's a bit of a mischaracterization here. Far from agreeing with Allstate's request to put a hold on depositions, Hook asked the court to order Allstate to proceed with previously noticed depositions. Yeah, of course. Again, of course. And far from apologizing, Hook contended that his misconduct was Allstate's fault. And he requested sanctions against Allstate for having the temerity to complain. No, for breaking the conference requirement. You broke the conference requirement. As a result, Allstate had no choice but to file the reply brief that Hook now claims was unnecessary. Far from being moot, it was unnecessary because you broke the conference requirement. You went with an ex parte motion rather than meeting and conferring. That's it. I mean, that's That's on you guys. He had to file a reply. He had to do that. Far from being moot, the reply brief was Allstate's only opportunity to respond to the multiple meritless arguments that Hook raised in his opposition brief. And although Hook disingenuously suggested that he was already removed from the case, in fact, he was fired after Allstate filed its reply. Setting aside Hook's revisionist history, it is clear that the time spent making sure that he ceased his misconduct and stayed away from Allstate's employees, lawyers, and their families was both necessary and appropriate. He was a real danger to them, the employees and the families. The judge actually, I shouldn't say the judge only did one thing right. He also threw out the protective order for Allstate's families later on. He said, yeah, I'm not going to grant that. They didn't provide any case that there was an actual threat. That's the summary of his words. It wasn't plainly stated like that. So it definitely wasn't both necessary and appropriate, right? Like we know it wasn't necessary and appropriate because the court said so. Indeed, the content of Hook's emails made clear that the relief Allstate sought, and which Hook opposed, was critically important. None of the requested relief was moot until Hook's clients fired him just a few days before the hearing. When he appeared in court, even Hook agreed that he should pay Allstate for the time it had expended through the date of the hearing. I don't think he said that specifically. But now, instead of owning up to what he has done, Hook again attempts to minimize the severity of his misconduct, shift blame to Allstate, and disingenuously characterize what Allstate's counsel needed to do in response to his actions. If anything, Hook's most recent brief proves that he still does not grasp the gravity of what he has done and the damage it caused. What damage? What damage did it cause? That's what I want to know. What damage did this cause? Ultimately, at the end of the day, even if you take Allstate and the judge at their word, you have a lawyer being a meanie. Lottie freaking da. The court should order Hook to compensate for the full $41,748 that his misconduct forced Allstate to incur. Forced him. A timeline of the events that led to Allstate's filing of its bill of costs refutes Hook's new arguments. In late November 2019, Hook began his campaign of misconduct that started with profanity-laced emails, escalated to slurs, and culminated in repeated threats of physical violence. The court disagreed on the physical violence part. Because depositions were scheduled for early December, there was no time to bring a notice motion to prevent Hook from being in a deposition room with the people he had threatened. Was there time to send him an email? Call him? Say, hey, what are you doing, you weirdo? Allstate therefore filed an ex parte application as soon as possible seeking dismissal of the case, which doesn't make much sense, disqualification of Hook, a temporary restraining order against Hook, a protective order regarding the depositions, and sanctions. Next week, the court issued an order noting that Hook had not responded to the application. The order suspended all depositions and ordered the parties, including the plaintiffs in this case, Mr. Baker and Ms. Oliver, to appear for a hearing on December 16th. The next day, Hook filed an opposition brief, purportedly on behalf of his clients, where he argued that his conduct was no basis for disqualifying him as plaintiff's counsel of choice, asked the court to order Allstate to proceed with previously noticed depositions, and vigorously defended his conduct as privileged settlement negotiations, hearsay, unauthenticated, puffery, and protected by the First Amendment and California's anti-SLAPP statute. Hook showed no compunction for what he had done. He needs to acknowledge he was bad. He must do that. Where do we go? To the contrary, he argued that Allstate was actually at fault for his conduct because, quote, defense counsel caused or contributed to the alleged situation by refusing to communicate with plaintiff's counsel. True. That's true. Like, you may think, you can actually go ahead and think that what Hook did was over the line and offensive to the rules of decorum and the way that an attorney should conduct himself. I think that's a little much, but I certainly see it. Right. And the idea that a court would not like what happened isn't all that foreign. But it doesn't matter if you believe that. Them refusing to communicate in settlement negotiations or to settlement requests, refusing to communicate at all, is actually a problem. Hook sought sanctions against Allstate for having brought its request for relief. In light of the potentially serious consequences that would follow if the court were to grant Hook's request that the case proceed uninterrupted with him as counsel. Oh man, serious consequences. Allstate promptly researched Hook's legal arguments and filed a reply brief addressing each of them. About a week after Allstate filed its reply and just a few days before the hearing on Allstate's application, plaintiffs fired Hook. Plaintiffs revealed that Hook filed his opposition without informing them of his actions, Allstate's application, or the court's order that they appear at the hearing. Hook then went on the Adam Carolla Show, where he continued to trivialize his misconduct and criticize Allstate. The Adam Carolla Show, hey, here we go. When a host of the show suggested that some of his emails included threats, Hook said that was bull poop. Bulls, hyphen. And he bragged that there is a limit to what the court can do to me and what the bar can do to me. That's true. They can't kill him. At the December 16th hearing, the court recognized the extraordinary severity of what Hook had done. And notice the court didn't do anything about the threats. Again, I have to point that out. Hook had brought shame to the profession. The court had never seen anything like Hook's conduct. The court also acknowledged that the relief Allstate sought was warranted. If plaintiffs had condoned Hook's conduct, this case was going to be history. The court was terribly concerned about the depositions Hook had pushed to reinstate and could imagine how those depositions would have proceeded. Could it? Could it actually? Probably the way the depositions go. Because plaintiffs had fired Hook a few days earlier, however, the court stated that the request to disqualify him as counsel had been mooted, and as had the stay on the depositions. Likewise, while the court acknowledged the concerns about keeping Hook away from Allstate's employees, lawyers, and their families, that too was mooted when he was fired. That's not... I don't know that that's actually what he said. I seem to remember that order. Let me see here. Where's that order? Where is this? Do I not have it in here? Oh, it's on my other computer. Dang it. In just a second. Is it? Nope. Here we go. I'll have it in just a second. Here we go. Let's see. Let's see what it says. Here we go. After considering the parties' briefs and arguments at the hearing, the court finds that granting a permanent injunction within this venue under these circumstances is inappropriate, nor has Allstate met its burden to obtain a permanent injunction. Accordingly, Allstate's request for a permanent injunction is denied. That's not moot. Right here. That wasn't denied as moot. Where did we go? It does not say it was mooted when he was fired. That said that that they didn't meet their burden. These dudes are lying. That's frustrating, man. That is frustrating. Like, imagine lying to the court right in the document. You said it was moot. No, I didn't. Evelyn Corbin says, hey, Nick, I'm promoting a GoFundMe I made for my best friend. She's fulfilling her dream by going to teach in Japan in April for a year. If anyone's interested in checking it out or supporting, Elena's Big Move to Japan is the GoFundMe. So you guys can go check out Elena's big move to Japan. Not the Japan. Elena's big move to Japan. I wish her the best. You know, hopefully it's a fulfilling and fun time for her. On the issue of monetary sanctions, Hook admitted that he owed Allstate for its costs and fees through the date of the hearing. The court asked Hook, quote, "Tell me why you aren't responsible for the costs and fees incurred in preparing the ex parte application and appearing here." In stark contrast to what he says now, Hook told the court, "I'll pay them, I'll submit, I'll pay." Hook will likely just argue that, you know, he's caught up, and what he was meaning was he would pay the demanded amount. Right? Now, the court may not accept that, but that's what he would argue. I was saying the amount they requested in their application. Allstate's ex parte application was not moot or unnecessary. Hook now attempts to rewrite this history after describing his conduct as merely uncivil. Well, what was it? It was just uncivil. Like, honestly, what was it? If it's not just like, what other thing was it than uncivil? I don't like lawyers. I really don't. I don't like it. He asserts that Allstate's response to the situation was also unnecessary. His conduct was merely uncivil. It broke the rules of decorum. It was unbefitting of the form. Yeah, right. Imagine these babies. Oh my goodness. Despite Hook's contrition, the response explains, Allstate elected to file an application that was largely moot, save for a request for sanctions based on its filing. The written record in this case demonstrates that no part of that is true. Nothing was moot until plaintiffs fired Hook. That happened weeks after Allstate filed its application and several days after Allstate filed its response to Hook's opposition. Ooh. In other words, Allstate's response was absolutely necessary and no less would be tolerable in light of Hook's threats of physical violence to innocent employees, attorneys, and family members. Hook is Kaiser Sose. Hook is Kaiser Sose, and all of them were about to be burned alive in their living rooms. Hook's meet and confer argument is absurd. Once Hook made his threat, there was no proceeding in this case with him as counsel. Under Local Rule 7-19.2, there's also no need for Allstate to schedule a meet and confer to obtain Hook's position on his threats. Hook now argues that if Allstate had met and conferred with him about the relief it sought in its application, the application would not have been necessary. Hook's own actions again belie his contentions. Hook did not withdraw from the case or agree to stay depositions. That's because you made an ex parte order that he was forced to respond to. Like, you can't just leave it out there. Because if he didn't respond to your order, the judge would have dismissed the case. If he would have just withdrawn as counsel, the judge would have dismissed the case. To the contrary, he aggressively opposed the application, asked the court to reinstate the notice depositions, blames Allstate for his conduct, and asked the court to sanction Allstate. Good. Good. Big Red Bear says it was criminal harassment, where execution is the only possible punishment to fit the crime. To violate decorum is to violate all that everyone everywhere holds sacred. He should do the honorable thing and end it himself, says the Big Red Bear. That is the most appropriate. I concur with your position. And this brings us to a related falsehood that Hook makes no less than 5 times in his response. His repeated contention that he has apologized to Allstate and its counsel. The court can scour the numerous filings and hearing transcripts in this case, and nowhere will it find an apology to Allstate or its counsel. Indeed, to this day, Hook has never apologized to Allstate or its lawyers, whether in writing or verbally, for any of his misconduct or for causing family members to fear for their safety. The fact that Hook has continued to peddle this falsehood is a testament to his lack of actual contrition. I really where is that? Do I have the transcript here? Why don't I have the transcript here? All right. Let's see. What up, Otis? I feel like he said I'm sorry a couple times. Let's see. Where is the transcript? Where's the transcript? Pay up, fuckface. Sorry. Oh, it's funny every time. It's funny every time. Why can't I? Oh, we just had the audio. Maybe I didn't have the transcript. Maybe I just played the audio. Anyway, okay. Well, I'm going to stop looking for it right now. Oh, all right. Allstate is entitled to fees. The fact that Hook has continued to peddle this falsehood is a testament to his lack of actual contrition. I feel like he apologized at that hearing several times. Now, did he say, look, lawyers, I'm really sorry for hurting your fragile feelings? No, I don't think so. But I do think that he apologized in court at the hearing. Allstate's costs and fees are appropriate. Oh, wait. Hook now suggests that the court should not impose sanctions for any fees incurred after the filing of the application. This too makes no sense. Hook should pay for Allstate's fees through the date of the hearing, just like the court ordered and just like he told the court he would. Allstate's costs and fees are appropriate. Aside from downplaying the severity of his misconduct, blaming Allstate for reacting to his threats, making false claims about apologies that never occurred, and offering a temporally inaccurate picture of what Allstate needed to do and when, Hook also challenges Allstate's billings as unreasonable. As an initial matter, in light of the gravity of what was at stake, there can be no doubt that Allstate needed to do the work necessary to prevail on its application. As the court described it, a whole lot of things would have happened in that conference room if depositions had proceeded, but none of it would have been a deposition. That's a... Hook's after-the-fact attempt to nitpick Allstate's billing entries should be disregarded for this reason alone. No, you don't get to just come up with whatever you want for billing. Like, that's not how that works. You still have to justify the billing as reasonable. More importantly, Hook's criticism should be disregarded because they are based on mischaracterizations of the contents of Allstate's billing entries. For example, Allstate counsel did not spend 8.6 hours to read settlement demands, as Hook falsely asserts, in addition to reading the over 100 emails that Hook sent, all of them like 4 words. The entries Hook appears to be referencing also included time spent researching bases for sanctions and dismissal of the case based on the emails, evaluating options for dealing with Hook's conduct, and outlining a motion to respond to the threats. The time spent researching and drafting the application was appropriate. True to form, Hook's suggestion that it was not is based on a misrepresentation about the number of pages in the application. And Hook overlooks that his behavior was unprecedented, not something that can be addressed through a form pleading. Hook also misrepresents that Allstate's lawyers spent 10 hours to review opposition papers, apart from the fact that 10 hours would seem reasonable to review Hook's 463-page filing. In fact, Allstate spent far less time than that. Hook comes to 10 hours by including the time spent outlining and drafting Allstate's reply brief. Hook's attempt to characterize this as simply reading his brief is indefensible. Well, didn't you block bill it? I think that's the problem, is that you block billed it, so we don't know what the breakdown actually was. Hook suggests, without citing any authority, that 20.1 hours was too much time to draft Allstate's 10-page reply, but a 2 hours per page ratio is well within what courts have found reasonable, especially in light of Hook's strategy of raising numerous novel privilege and evidentiary objections to defend his threatening emails. finding it reasonable to bill 120 hours for a 41-page brief worked on by multiple lawyers and consisting of one uncomplicated issue, which had already been briefed by parties and discussed at length in a well-written and thorough opinion at the district court level. Hook suggests, again without citation to authority, that all states' counsel should not have billed for the time needed to travel to the hearing. This argument, too, is contrary to law. Additionally, if Hook did not want to pay for 2 lawyers to attend the hearing, he should not have made threats to 2 lawyers. Oh, man. Now they're tough. And Hook's emails show that he knew exactly where counsel would be traveling from when he made his threats. Shallow criticisms aside, Hook does not and cannot dispute that every time entry reflects time that all states' counsel had to spend as a direct result of his bad acts and the arguments he raised in his opposition brief. For the foregoing reasons, as well as the support found throughout the record of these proceedings, the court should order Hook to compensate Allstate for the full $41,748 that it needlessly incurred. Needlessly incurred is probably accurate. Needlessly incurred is probably accurate. That's the most accurate statement. Look, of course they're going to fight for all their fees, right? But it does seem they padded that bill a little bit. They knew they had it won. They knew the judge is sympathetic. So they threw up the bill with a massive amount of money attached. Massive amount. What 463-page filing are they talking about? They're talking about his initial filing? Because his initial filing isn't part of this. Like, he shouldn't have to pay for the initial stuff, right? He should only have to pay for what damage his emails caused. And bringing the cause of action isn't part of that. I don't know what 463-page filing they're talking about. Let's see. See, that's 23 pages. 11 pages. So, 11 pages again. 4. Where are they getting this 463-page thing from? That's what I'm curious about. Let's see. I can't actually see the original complaint in this case, so that might have been the original one. Let's see. Let's see if we have the cover sheet. Yeah. I don't know what they're talking about. We had to review a 463-page document, not as a result of these emails. Oh my goodness. All right. Well, anyway, that's where Hook is. Oh, I have Peter Klee's declaration. He just says, he never apologized to me. All of our time entry stuff is real. That's it. That's all it says. It's right here. Very, very, very short thing. Never said sorry. All right. All right. All right. Let me get to the next issue here. Oh my God. Let's see, where am I going to find this? Okay. All right, I'll have to find it in a different spot real quick. We're going to talk about Doucette now. Just for a little bit. Mainly because he lied about something, and that's just annoying. I mean, not that it's surprising anymore, because at the end of the day, a liar is a liar. A liar is a liar, and a loser is a loser. Let's see. I'm just waiting on the internet here. Goodness gracious. Let's pull this up. Here we go. Here we have a little bit of T. Gregisms. Pull this up real quick. Oh my goodness. I am so sorry. I should have blocked out his face. I apologize. Here we have T. Greg. Low T. Greg. So BHB, I guess Carrie Christie isn't a person to Greg. He just unacknowledges a woman. I don't know. Maybe it's from years of women not acknowledging him. He's bitter. I'm not sure. But he just unacknowledges her existence. That's lovely. Just begged the defendant's legal teams for an extension to complete Vig's appeal brief. Yeah, it's pretty common in appeals cases to ask the defense teams for an extension. And let me tell you why. Why we would need to do that. Texas Rules Appellate Procedure. Why would anyone need to do that? Okay. Rule 10, motions in the appellate courts. Here we go. So Rule 10, 10.1 of the Texas Rules of Appellate Procedure. Here we go. Motion. Unless these rules prescribe another form, a party must apply by motion for an order or other relief. So if you want an extension of time, you must file a motion for it, right? Makes sense. The motion must contain or be accompanied by any matter specifically required by a rule governing such a motion. State, which that comes up in a little bit for a motion for extension. State with particularity the grounds on which it's based. Set forth the order or relief sought. Be served and filed with any brief, affidavit, or other papers filed in support of the motion. And in civil cases, this is important, except for motions for rehearing and en banc reconsideration, so that's not what a motion for an extension is, contain or be accompanied by a certificate stating that the filing party conferred or made a reasonable attempt to confer with all other parties about the merits of the motion and whether those parties oppose the motion. Oh wait, I boomered it here. Sorry. Here's the rule. They have to. You have to ask the defense. You have to ask them before filing a motion for an extension. You have to say, hey, are you going to oppose this? Because you have to know if you're going to have to argue about it. You're going to have to know if there's going to be some reason for it. Now, motions for extension on appeals issues take a lot, like they're very frequent. Happens a lot. You can find, heck, in reviewing appellate appeals cases in Tarrant County, you can find tons of extensions for appeals. You can find them filed in many of them. In this case, you have at the start, 17 causes of actions against 4 different defendants, right? That are all being appealed. So you have 17 matters. You also have the matters of the fees, the contingency fees, all of that stuff is also being appealed. So now you're kicked up to adding another, at minimum, 8. So you're at 25 issues. That's a lot of briefing that has to be done. That's a lot of briefing. You can't just attach exhibits with your motion like you could in the initial, or with your brief, like in your original stuff, right? You include with your motions or with your memorandums or whatever, you would include a bunch of exhibits and reference them in your footnotes. With the brief that's going into the appeals case, you have to actually reference the record as it sits, like the existing record that is before the appeals court. You have to, so you can't just like copy and paste citations. You can't do that. You can't just create your own. You have to go back to the record. So you have to review this thing. And I don't know if you guys remember, but the record in this case is thousands of pages, right? You have all of the deposition testimony. You have all of Ron Toye's tweets. You have all of the documents that have been filed so far are part of the record. All of the motion practice is part of the record. It's huge. I mean, we haven't actually seen the record specifically, but presumably Vic's team would want to include as complete a record as possible to be able to point to where in the record all of this stuff is. But even at the bare minimum, you have hundreds of pages of pleadings, plus the transcripts of all these people. So to suggest that, one, that an extension is unreasonable is incorrect. And the idea that the court won't grant an extension, it's certainly possible that the court would refuse to grant an extension. It's really unlikely that the court would refuse to grant an extension. But what's interesting about this is how it's mischaracterized. Why? Because T. Greg Doucette is a propagandist. That's it. He's a propagandist. He's a dishonest broker in this. He always has been. He was never neutral, but he tried to pretend to be neutral for a while. But here he is. He's getting apparently information directly from the defendants, right? Now, which defendant? I mean, I think we know. Only one of them is trying to lick that bald head for sexual pleasure. But it's pretty obvious. But the interesting thing is, I guess it's not that interesting. I mean, if I had come out with a tweet like this, right? You're the agent! You're on the legal team! You're practicing law! The nonsense is telling, but but this is silly. So have they begged the defendants' legal teams for an extension to complete Vig's appeal brief? I would imagine they have asked the defendant's legal team as a matter of the conferencing requirement for the extension. Said, hey, we're going to file for the extension. Do you guys oppose it? I would bet that the defense legal teams said, of course, we're not going to oppose it. Because they know that the appeals court's going to grant it. And because, remember, the legal teams for the defendants also have to respond and may want an extension themselves. And if they oppose the first one, but then want an extension when they get that massive document dropped, because again, there's going to be 35 plus matters that are on appeal, and they're going to have to, I mean, each one of them is only going to have to respond to their sections, but that's a lot of work. They're going to have to track down all the citations and make sure they're correct and all of that stuff. They have to do that. They're going to do that. Of course they are. And then they're going to have to write their own brief. And law firms have multiple things going on generally, right? Like a law firm with multiple attorneys does not just have one matter on the table. I think Lemoyne's got several matters that he's working on. that he mentioned. I know Beard, Harris, Bullock, and Hughes has more than just Vic's case. Significantly more workload going on here as well. So again, like I've been talking about this. This is likely the outcome. They're going to ask for an extension. They have to confer with opposing counsel on that extension, and to categorize it otherwise is just simply not correct. Like there's maybe I'll be charitable and say he's just stupid, but I think it's more likely that he's a liar and stupid, but a liar. So, yeah, there you go. This is about all I want to talk about with this. I'm not going to give him a ton of time here. I'll let him eat the sweet justice of 88 likes on Twitter. And look at this. And frees up JSL to ask for reciprocal extension on the attorney fee brief too. He does know that Jay Sean isn't writing the brief, right? Like, didn't Jay Sean say he's not doing the appeal in court? They have their appellant guy doing the appeals, I thought. Unless Jay Sean is doing the notice of appeal, I don't think that's the case. Where do I have this? Oh gosh, I'm not going to try and find it right now. But here's the thing. Frees up Jay Sean Lemoyne to ask for reciprocal extension on the attorney fee brief too. Like, oh, what a strategic victory. Even if Vic's team filed their thing on Monday, no extensions, right? Let's live in that world for a second. Vic's team files their appeal brief on Monday, no extensions. Jay Sean says, I need, because of X, Y, or Z, an extension on my reply brief. He's going to get it. He's not freed up to ask for reciprocal extension. Wait, beg? Would it be begging at that point? Of course he was going to ask for an extension, or of course he would get an extension if asked for. The appeals court is not ridiculous. Like, courts grant extensions all the time. Courts grant extensions after people miss a deadline frequently. Because they don't want to just now, if there's a habit of it, of course, they're going to dismiss the matter. If it seems like one side is just habitually missing the mark. But a lot of times they will offer an extension for pretty basic circumstances even after. Now, not at the appeals court level as much, but just in general, courts are not like, oh, you missed it by a day, you're going to go. This is why I was trying to lay out back when they had their technical difficulty on the filing, that it wasn't going to be a big deal. Like, the defense tried to make it a big deal. There's no way the court was going to be mad over a 15 or 30 minute late document, right? The court probably would have waited another day, 2 days for the document and been okay with it if they could demonstrate the technical error. It's just how they work out. Like, ugh. But that being said, this is ridiculous. This is a ridiculous simulacrum of a human, and I should never be surprised anymore by him. But I can't not be. He's too stupid to deal with. I don't know what else to say about that. I suspect we will see a motion for the time extension. I am gonna guess that motion will be unopposed by defendant's counsel, and I am gonna bet that the defense counsel, who probably sent this to T. Greg, and they sat there and made their soggy biscuits together before their docking session, I'm gonna guess that guy agreed to it without issue. I'm gonna guess that there was no problem agreeing to the extension. Because, why? Repeat after me. These people are not only liars, they're abject scumbags. Absolutely terrible. Absolutely terrible. That's the nature of it, right? Like you say one thing in private and then you say something else in public. Oh, sure, it's fine. Oh, Lolly's begging. Well, whatever. I mean, again, maybe T. Greg's just stupid. Maybe his source was like, hey, before you tickle my turtle head, I just wanted to let you know that Vic McNignugna, he asked for an extension today and we let it happen. And T. Greg's like, he begged you! Ha ha! No, he didn't. Yeah, he did. Maybe that's what happened? I don't know. But anyway, that's there we are on that issue. All right. I have the Meyer versus Wade document. I don't want to go through it tonight. It's 13 pages. We've seen it. Let's go through just the subheadings. And then we'll call it a day. I'm still mildly reeling from all of the dealing with sickness that's been going on, and I'm kind of in the mood to wrap up the stream. Frankly, apologies, but let's do that here. So we're just going to go through the subheadings, and it'll give you an idea of the arguments. If you've been following Meyer versus Wade, you know these arguments already. They're going to be largely rehashed. And that's not a criticism. This is what they have to do. They have to preserve the matter on appeal. And by levying their objections, they preserve the matter for appeal. So this is Wade's, oh my goodness, objections to the report and recommendation of United States Magistrate Judge regarding defendant's motion to dismiss. So again, just a brief recap. They filed the motion to dismiss for lack of jurisdiction over Mark Wade. A magistrate judge, not the district court judge, but a magistrate judge named Lee Yackel, he reviews the document. He makes a report, a memorandum report to the district court judge and makes a recommendation on the course of action. And then the district court judge can sign off on that order. He can sign off and say, yep, I approve of the recommendation granted by or given by Magistrate Yackel and implement it and it's good. Or he can say, I disagree with this based on the objection or based on my own decision. He can disagree with the recommendation and issue his own order. So technically the jurisdiction is not finalized until the judge actually signs the order. And they have, I think, 14 days from the issuance of the recommendation to file their objection. That's where we are right now. This is their objection. But let's check the headings. So introduction. Tortious interference claim. Fifth Circuit precedent requires a showing that defendant knew plaintiff would suffer the brunt of harm in Texas. Again, this argument has failed every step of the way. Primary case relied upon by the R&R likewise does not support an exercise of personal jurisdiction. So he's saying that the magistrate judge is incorrect. But as we know, judges are never incorrect. So that can't be true. Judges are never incorrect. We've learned this from the Vic Mignogna case, that a judge can never, ever get law or facts wrong. Not once. In fact, there's a Spurg out in the chat. who thinks that judges cannot ever be wrong, which is great. See the same stuff in here. They're quoting Twa, blah, 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 saying that the judge is wrong. Respectfully, the report and recommendation also erred in assuming the knowledge requirement was not part of plaintiff's required showing. Same thing. Wade indisputably did not know plaintiff resided in Texas at the relevant time. Doesn't have to. We've been through this a million times. Doesn't have to. Plaintiff's defamation claims. It's the same stuff. He didn't know. The R&R's conclusion in regard to this Houston claim is based on the same erroneous premise regarding application of the effects test. Effects test in particular is showing the defendant knew plaintiff resided in Texas. He's in Houston defaming a Texan in front of a Texas crowd. Like there is no way that you can be in a state committing a tort especially about someone in the same state, but it doesn't even matter if Meyer's in that state at that point, right? It doesn't even matter. He's in the forum committing an intentional tort. He is subject to the jurisdiction of the forum. It doesn't matter what he knows or anything like that. This is a silly argument. I know he has to preserve it. Zen calm. Zen calm. Zen calm on this. But that's what it is. That's what it is. I gotta they have to do this. I have to remind myself, serenity now, that they have to do this. And but yeah, it's the same arguments, the same case citations. We've seen it 5 times now or whatever, and it's just getting old, but it's not their fault. That's how the jurisdictional argument has gone. They had to do one with each report and recommendation. Now there's been 2 of those. They had to file their initial problems with it. They may appeal it, and if they appeal it, we'll see the same arguments again. If they appeal it, they're going to just try and drag out your boy Zach and bleed him dry of money. That may be the strategy, ultimately. It'd be really interesting to get discovery on who's paying their bills, because this is getting expensive for both parties at this point. More expensive for Wade, as he has less of a GoFundMe, right? Unless someone is paying for it. And it's very possible. Marvel could be paying for it. Wade's homeowner's policy could be paying for it. Although he may be renting. I don't know. But there's a lot of stuff going on. Anyway, that's where we're at. Oh, I didn't show you guys the document. Oh my goodness. Here. Sorry. Real quick. Tortious interference claim. Fifth Circuit precedent. It's right here. I have, goodness gracious. I forgot I turned that thing off. I'm so terrible. There's the Twa misinterpretation that they claim. We've got erred in assuming the knowledge requirement was not part of plaintiff's required showing. Wade indisputably did not know plaintiff resided in Texas at the relevant time. It's not indisputed, actually. They've disputed that. They actually just said it. He knew. He knew or should have known. There you go. And then here's the defamation claim. And it's important to remember, like, jurisdictional arguments favor the party seeking jurisdiction. Like, they want the court to find jurisdiction unless it would be grossly inappropriate. So, there you go. That's it. It's not a super complicated document, but it is 13 pages, and I don't really want to read the same arguments again. Plus, it's getting late, and we can wrap up this show. We can wrap up the show. Thomas O'Hanlon says Minnesota judge arrested and convicted for evidence tampering and got jail time. Ooh, who? Who? Oh boy. All right. Oh my goodness. Well, that's the show we have for the evening. I've got a couple chats to polish off, and then we will go over to Twitch. If you are so inclined to join me on Twitch, please do so. I will be putting together that short video on Tulsi versus Hillary, hopefully to really make it concise. I'm considering going through an impeachment day argument, or impeachment day, 6 days. 6 days of impeachment argument analysis for each side. The problem is, so Peter Schiff came out and he said that the Republicans are deflecting and distracting from the issue. Okay? Big headline. Big headline. Yes, of course they are. Because this isn't a criminal trial. It's not a civil trial. It is an impeachment proceeding, which is a political topic. It's about influencing people. It's not about finding whether or not there was XYZ was infraction was committed and whether or not there is guilt associated with it. That's actually a separate trial that is optional. That would be through the criminal courts, likely after a president would be removed from office. What they're doing now is entirely an attempt to deflect and distract. Just like when Peter Schiff suggested that he heard, now he says this on the Senate floor or whatever, he heard that that Donald Trump or his team had threatened Senate Republicans that their heads would quote be on a pike if they went against the president, right? That is deflection and distraction. That's not at issue here. What would be at issue would be the alleged obstruction of justice and obstruction of Congress and whatever the other charges. It doesn't really matter at this time. It really doesn't matter. But so I'm thinking about doing it, but I'm just mildly depressed at the thought of it because there isn't a legal argument. These are political arguments. And they're meant to sway politicians. They're meant to sway, more importantly, the constituency of politicians to give them the security to vote against the president. That's what the entirety of this process is designed to do. At the end of the day, we want to convince the constituents that we are justified in our vote. That's it. Whatever the vote may be. I'm justified in voting for the president. I'm justified in voting against the president. Here's why. We put it all on national television. And I hope you'll vote for me in my next re-election campaign. That's the end of it. Adam Schiff. Dang it, not Peter Schiff. Yeah, you're right. You're right, Adam Schiff. So that's, I'm thinking about doing that and going through it. Again, it's not legal arguments. These aren't even criminal charges, right? Obstruction of Congress is a made up sort of thing. Oh, president vetoed a bill. Obstruction of Congress. President asserts executive privilege. Obstruction of Congress. President doesn't implement policies that Congress enacted through the Clean Air Act. Obstruction of Congress. Yeah. George Bush was actually sued by Congress for not doing the EPA in the way that Congress wanted him to, and he won, for example. That was an obstruction of Congress, even though Congress laid out goals that they wanted the president to do. They disagreed with how he did them, and then the president won on that issue. So this whole idea of these charges, they're not criminal. There's no legally objective standard. There's not a lot of precedent for it. There's nothing... It's all politics. So I would be analyzing them from a persuasive nature sort of standpoint. It's so weird. They're arguing over the ability to have a motion to dismiss. Why? Like, you're either going to make the arguments or you're not, and then you're going to vote. And that's it. That is the dismissal or non-dismissal, as it were. So there you go. I'm thinking about doing that. I don't know if I'll do that on a live stream. I'd love to do that with Viva Frey. Maybe Viva Frey and I could get together and argue back and forth about it or something. But he doesn't like this time slot at all. It's really late for him. So it would have to be a daytime show. But last time I did a show with him, it was really fun. We had a good time. And I would like to do one where he's a little more awake because it's in his thing. Hook on my show win. Man, I don't know if it's going to happen. It's probably not going to happen before his order is issued. I would love to have Hook on the show. I would love to. But anyway. Let's wrap up here. Let's go with the chats, and then you can come watch me boomer through Dark Souls or whatever on Twitch if you want to. It's a fun time for everybody but me, mainly because I'm bad at it, so I die a lot. But that being said, we'll see how that goes. All right, on to the chats. Sigma Zero says, TG's a 6 at best. Tulsi Gabbard is a 6 at best. Only hot relative to the shoggoths that flood the Democrat Party ranks. Have you guys seen Hot Chicks for Bernie or Hot Girls for Bernie? Oh my God, some real winners in there. Woo! Hot chick with ugly friends phenomenon, nothing more. Nothing more. I do not find Tulsi Gabbard attractive. I'm not saying other people shouldn't. I just don't. She's not my type at all. Not my type at all. Bad Dragonite says Pornhub should make a browser that filters out all safe for work sites. Jay says if you get deposed from the Vic thing, you need to hire Chris Hook as your attorney. Chris, objection, West Nile pussy boy. That would be great. Judge Brennan, huh, Thomas? I'll have to look that up. That's pretty interesting. All right, here we go. Some nobody says, hit that like button, fug bots. Remember, you guys are all bots, apparently. The bots are out in full force. Yes, man, 2044 says, don't get woo flu. I'm not getting the woo flu. Some nobody says, hit that like, gay boys, or get your face tattooed. BTL Video Production says, here comes the boom. Some nobodies. Nick, try Druid Stone on Steam. Game's great. I'll check it out. Nunya Biz says Tardy and Butt Party. Oh, Bad Dragonite sent a rainbow sticker. Thank you. Donald Michael says first live stream. Love your content, man. Hey, welcome. Welcome. I hope you're still around. Thanks for contributing to the channel. I appreciate it. Dax Terminax has joined as a member. Thank you. Dex Terminax, not Dax. Jospy says, messaged on Facebook, not a Twitter, sorry. Wondered if you'd have interest in talking to Josh Pillow. He was just on Dankula's stream. He served time for sending edgy comments in a video game. Yeah, that would be great. I'll see if I can find your message on Facebook and respond to you. Sorry, buddy. Cowboy FMJ91 says, since Michelle Carter being released early from prison has restarted the discussion, was curious of your legal opinion on somebody motivating someone suicidal and if they're legally liable after. I have a real problem with it conceptually. It's got to be extremely case by case. I think the problem with Michelle Carter is that, man, she looked really bad in those texts. Like, I don't want to do it. Get back in that car, you chump. Like, whatever. She looked really bad. She looked really evil in how she took it on. I mean, it's tough though, because there's no one forcing you to do it at the same time. And it's been long held that you can't induce someone to suicide because at the end of the day, it's a suicide. They did it themselves. I don't know. I don't want people inducing people to suicide. It's got to be really limited, really hard to prove. And I'm not familiar enough with all of the evidence they had against her. That'd be really interesting to talk about. Maybe great to get her on the show. Except we might all be in Minecraft at the end of the day. It'd be worth it. EP, welcome to the membership. Thank you for joining. I appreciate that. Mike Downey says, I'm Nick Rekieta, and you should all sub to Common Man Cast. I would also smash Tulsi if I didn't have Lady Rackets. No, I wouldn't. I'm sorry, man. You lost me on that one. You lost me on that one. Howling Warwolf says, with the Marvel comic universe turning all its superheroes female, Arms Girl would be perfect for Mr. Fantastic since she's already got the arms for it. Or Beast, right? Just paint her blue. Her arm proportion is already correct for that. Richard Pierce says, Nick, I've been uncontrollably flirting with women as well as guys pretending to be women. I think I've been infected with the coronavirus. Oh, no. No, corona. Oh, dang it. R.W. Bimble says, Nick gets super chats. Lemmy gets jealous. Rural says, as the lemon, what is best in life? Last Sigil says, Gabbard spoke with Bashar al-Assad unethically. Ooh. I'm not aware of that. I don't know anything about it. I don't really care. Joshua Heggie says, Tulsi claims per se. That means damages are presumed. Damages are presumed for the purposes of fulfilling the damage element of the case. Damages are not presumed for the damages portion of the case. So if you win, the damages still have to be proven for your recovery. Can't say, oh, well, we presume 50 million in damages, so there's damages. No, you still have to prove up the damages either way. They're just presumed for the damages element of the case. But only if it actually is per se defamatory. Not 100% sure it is. Not 100% sure it is. And I guess it really will depend on how the court resolves the question of what did they mean by asset? What did they mean by asset? Were they even talking about Tulsi Gabbard? I mean, because she says they were. The statements are mildly vague. Now, I think they were. Don't get me wrong. I think they're talking about Tulsi Gabbard. And I think what they meant by asset is defamatory. I do. I'm just talking about the argument they can make. Right? R.W. Bimble says, Ron wants you to get super chats. Ding. Ron sent me another message the other day that is very long, and I haven't read it. It's really polite because I think he wanted me to read it. So that's why I didn't, because I'm a dick. I don't do people's PR for them. I do my PR for me. So, here we go. Cam Sama. MBR Mad Black Rapist is not a pedo, not gay, but 100% a rapist. Oh my goodness. His daughter was also raped. Her best friend was raped. Her story on Kiwi Farms, so sick. Yeah, I haven't read his story or her story or anything on Kiwi Farms. I heard about it. I briefly looked for it and I was like, I'm not really interested. I'm not super interested in talking about Mad Black at all. I just perpetually hope it's untrue because it's such an awful accusation. Some nobody says Clee feared for his life because he's a pussy. Some nobody says lesson of this, cancel Allstate, F these people. Hannah the Mad Black daughter, oh god, says stop it daddy, stop it, get off me, no, this is rape, no, get off me, Gabby was right, this is why everyone's calling you the Mad Black Racist MBR. So there's that. Then again, I just hope it's not true. Because man, that's awful for kids, of course, to have to endure anything like that. Gelth Walker says, can I get the Discord link now that I have upgraded? Upgraded. Are you talking about channel membership? I haven't fully done that yet. I haven't decided that yet. Marius Van says, hook on your show when? I don't know if he'll ever come on the show because right now, especially, he's still got a judge who has to decide his ultimate fate, and then he may have to appeal it. I don't know. I would love to have him on. I'd love to have him on and talk about other stuff. I think he's an interesting guy. He's got a nice voice to listen to. So, you know, if you go listen to that Adam Carolla interview, I think he'd be great on the show, but I understand why. Sakaki Onsai says, Senator Joni Ernst, Republican from Iowa today, says, quote, within 2 hours, I thought that the White House counsel and their team entirely shredded the case presented by the House managers. So there's that. All right, guys. we'll see. We'll see what happens. I don't know if I'm going to do a show tomorrow or not. I have not decided yet. Really depends on how I'm feeling and how many more kids I have to take care of. Because, like I said, it's been exhausting. And, but you know, we'll see. As always, I will announce it if possible. But you are welcome to join me in just a few minutes over on twitch.tv/Rekieta Law for some Dark Souls. And that's been a fun sort of thing. I'm going to fight some dragon or something tonight. Probably a mistake. Nicker Jim says, I have information that will lead to the arrest of Hillary Clinton. Oh, buddy, you better take cover. You better take cover. All right, guys. Hope you guys have a good evening. Otherwise, hope you come join me on Dark Souls. It's always fun. And, yeah, we'll see what's happening. We'll see what's happening. Hope you guys have a good night. Peace. Peace.
No one explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, his lady is fair, and she handles herself with the grace of one who has borne many children. As the wife of a lawman, she makes sure that he has the time and the place to provide for them there. So pour out an art bag, a bow, more a love rug. The spirits flow as the ones who get unemployed. So pour out a glass for the tea, post on Twitter as we hear Lost Planning tonight. From the white shores of Nan to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, the guests are all plentiful, from Doucette to Drexel. They bring their perspective and spice to the mix. But the reason we're here and the one that we cheer is the one who is showcasing us his career. Get unemployed, so pour out a glass for the tea, post on Twitter as we hear Lost Planning tonight. From the white shores of Nan to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make